And why don't you start with about 20-second countdown? That'll give people some time to trickle in.
Good afternoon, Elder Justice Warriors. Thank you for being with us here today. My name is Nicole Howell, and I'm the Executive Director for Empowered Aging, and I'm eager to continue our learning together today. Just a reminder, this is an interactive session, and so we encourage everyone to think of your questions and either add them to the chat or the Q&A, but also start off now and introduce yourself in the chat. Maybe say your name, what you do on behalf of older adults, and where you're from. This helps us to see the bigger network of elder justice warriors out there and how we're all connected and looking to address the same things. As a reminder, access is important to us. We have two available options for you. Please enable the closed captioning, and we also have ASL interpreters with us today. You can just see that in your Zoom feed and highlight that screen if you feel appropriate for you. And as a reminder, this is a series. We've been meeting for more than a year now. And so we meet on the third Thursday of every month from 12 to 1. I also want to say today is in fact a holiday for many of our friends. It's Yom Kippur. For those of you who are celebrating, I'm sure you're seeing this later via recording. I just wanted to wish you a good celebration and let you know we're with you today and thinking about you. This would not be possible without the help of our sponsors. We are generously sponsored by Kaiser Permanente and have several planning partners like California Department of Social Services, Archstone Foundation, and John Muir Health. Now, we are joined today by an old friend of mine. His name is Mark Redmond. He has been working in elder abuse for many years. Not only did he earn his bachelor's degree from Pepperdine University, he also attended University's Pacific McGeorge School of Law. He is also a former long-term care ombudsman like myself. Now, he has worked for many years as an attorney, both in the district attorney's office in Placer County, and then later in private practice, combating elder abuse. So today's conversation begins out of what many of us providers have been working in for many years. We love working with our legal services and our legal aid organizations, and they do amazing work. But sometimes we encounter clients who need more. They need to work with an attorney in private practice that has the bandwidth and the capability to take on maybe longer cases that may require more attention. But I don't know about you, but I never know who to refer to. I see every other day, either on bulletin boards or in commercials or advertisements, someone saying they're an elder abuse attorney. But I never want to refer to a client to someone I don't trust and know that they're going to be taken good care of and receive really just the hardest work on their behalf. And so today, Mark is here with us to talk to us about how we can know when to work with an attorney in private practice. This is a continuation of our conversation that we had last month surrounding amicus briefs and letters of the court, essentially, and friends of the court. And so this is going to focus on individual cases and how we can know and when to turn to attorneys in private practice. So with that, I turn it over to my good friend and board member here at Empowered Aging, Mark Redmond.
Thank you, Nicole, and thank you for the opportunity, everybody, to speak and to share with you a little bit about my experience and my current practice now. This is amazingly to me my 29th year of practicing. It's almost exclusively been as a civil litigation attorney, and the past almost 25 years has been almost exclusively on behalf of elders and their families. I am licensed in California and Washington State, but because of pro hoc vice laws, we are allowed to practice elsewhere under the licenses of other attorneys in other states as well. So I have the privilege of trying to help elders and families across the United States. I am a former certified long-term care ombudsman. I got started and interested in in elder issues because of the blessings of having wonderful grandparents myself, and remembering with regard to my dad's mother in particular, her time in a nursing home at the end of her life. I was in high school. I remember how strange it was, the types of complaints that she had made, things about her false teeth being thrown away with her meal trays seemed unbelievable to me, and all the embarrassment and upset that caused. The home asking us to cut out a hole in the top of her television set and chain the television set to her bed rails so that the television set wouldn't go missing. I didn't know it at that time, but those type of frailties, injustices, lack of dignity kind of sat with me for a long time until I had the opportunity to go through long-term care ombudsman training in Sacramento, California in the late 90s. And that really gave me a chance to go inside of care facilities, see the ones that worked, see the ones that didn't work, and most importantly, over time, for the ones that didn't work, to see where the skeletons and bad evidence was hidden and how it was hidden. So again, 29 years of practice, about 20 of them doing predominantly physical abuse cases, but over the last 10 years, financial abuse cases have been more and more what has occupied my practice. And today I want to share with you types of financial abuse cases that you may not run into every day, but that are the bulk of my practice and can have positive outcomes. So let's go to guiding questions. Thank you. And we'll start on this for our financial abuse discussion. And the first one will just put us on the same page. And it's probably something all that we understand too well together, why elders are targeted. I want to spend just a little bit of time on that. And then why people don't prosecute these cases, particularly as civil cases, why they don't get prosecuted. Some examples of scams and successful case outcomes. And then next, again, because I'm a civil attorney, what I can't put people behind bars, but what I can do is to recover for my clients and their families. So where does that elusive money come from? And then I want to be very sensitive to all of you listening and let you know that I'm trying to tailor what I'm saying so that the next time you hear about an elder financial fraud, particularly one involving a business or a professional, like I'm going to spend most of my time talking about, you'll have tools and ideas as far as what can be done. So why do elders get targeted? We know it too well. They're sitting on a lifetime of savings, and they really are a generation that believes in looking somebody in the eye and shaking their hand and having a general sense of trust, and that you can take a man or a woman at their word and that's going to be good enough. And there may have been a time where that was good enough, but in today's age, predators really take that to their advantage in dealing with the elders. And elders are particularly a reluctant group to use the internet to do their due diligence on who it is that they're doing business with. They're also lonely, and they've got the time to invite these people into their lives and sometimes into their homes. And that is a great way for a bad guy to ingratiate themselves to the elder, and for the elder to feel that they're building that sense of trust, and thus even be less likely to do their due diligence on who it is and what the company and services are that they're doing business with. The other thing that we can recognize is that as elders become more frail, physically frail, and kind of feel some of their physical abilities diminishing, they have a tendency to overestimate their decision-making, and particularly their ability to know who to trust based upon their long lifetime of knowing people and kind of sizing people up and opportunities up. And then lastly, in case there wasn't a better reason for people to target the elders, it's because elders are particularly afraid to admit their mistakes. They know that this can have embarrassing consequences at a minimum within their family and their social circles. It's further admission of the diminishment in their lives overall, and what a dangerous place the world is. So without belaboring it anymore, those are the reasons we probably all see and experience elders getting targeted. So then, why don't cases get prosecuted, especially civilly prosecuted? Well, let me give you some examples of the types of cases that make it into my office, and that will get to the successful outcomes they've had. There are things like investment scams, most commonly. You'll hear about all kinds of investments in real estate or stocks, and it all turns out in the end just to be a Ponzi scheme, not to be really a real investment at all. There's also fake prizes, fake inheritances that largely get turned into scams, lotteries, and other types of winnings. So those are some of the examples. And the number one reason that they don't get civilly prosecuted, again, goes back to the fact that they are overwhelmingly underreported. The statistics differ, but they're clear in one sense. At their very best, it's maybe 5% of all elder financial abuse situations that ever get reported to any sort of law enforcement or a person who can do anything about it. From a criminal perspective, and again, I practice in the civil arena, I've got to imagine that the intent of the defendant or the business can be sometimes difficult to prove. Proof can be a difficult issue, especially where you have elders that are reluctant to come forward or want to spend the final months or years of their lives dealing with a tumultuous criminal case. From a civil perspective, there's really two reasons that I think these cases don't get prosecuted, and I'm going to spend a lot of time on this today. One is they are sadly not economically viable for us as civil attorneys. And then secondarily, there's a lot of collectability problems where it's just hard to, even if you win the case, get the money back. So let me start with the first one, why it's not economically viable. These cases, seniors typically get scammed out of $5,000 to $50,000. And while that can be a lifetime of savings and, deeply breach their trust in life, it's hard for us as civil attorneys in all candor to litigate a $5,000 or a $50,000 fraud. It just is. And then what we've done to try to remedy that is candidly to aggregate plaintiffs, or if one senior has been scammed out of $50,000, give my investigator a month or two, and I bet he will piece together 10 or 20 or 30 victims or more for us to start a case under. And then you're talking, instead of one senior in a $50,000 matter, potentially recovering, let's say, for 20 seniors and $1 million of recovery, which also gives us a much larger hammer to swing at the bad guys. And of course, there are opportunities to get general damages or emotional distress for elders and attorneys' fees and trebling of damages. But all of that really goes into that next issue, and that's the collectability problems. Elders are super skilled at defrauding innocent elders. What they're not so good at is hanging on to any of their ill-gotten gains. They tend to spend it on lifestyle choices or successfully squirrel it away in far-off jurisdictions or to people that are, darn near impossible for law enforcement to track down, let alone a civil attorney like myself with less resources. But I do prosecute these cases, and the examples that we're going to talk about now are really examples where if the defendant, the fraudster, doesn't have the ability to pay, there's backup means or other means that we can potentially collect on behalf of our elders. Because the last thing we want to do is have an elder go through a fraud and then take them down a year's worth of litigation or 18 months of litigation, only to have a piece of paper that says we won the case, but no ability to collect. So let's talk about this gentleman here, Lee Loomis. Lee Loomis was the Bernie Madoff of Northern California. He operated a Ponzi scheme of about $100 million. He is a good case example, not whereby he could make any of the seniors whole, but whereby we could find co-conspirator liability and get some of Lee's co-conspirators who were economically viable to pay our older clients back. So Lee's case, and for people in Northern California, they may even remember him. He had an investment opportunity called Loomis Wealth Solutions. It sounded legitimate enough at first blush. He wanted people to invest in real estate. And this is like the 05 onwards time period. He promised a high, but not pie in the sky type of return of about 12%. But as you got further into what he was offering, you begin to see the red flags of the problem. And one of them was his famous pitch for people to equity harvest out of their homes. He called them equity in people's homes, their lazy money, and to put that lazy money to work. Take out second mortgages and lines of credit on your home and invest those proceeds with him. The other thing that Lee did was he had his investors invest in life insurance. And he pitched this in a seemingly smart way. Life insurance has tax advantages to it. The proceeds of life insurance policies typically aren't taxed. So he said, take the profits that you're making now with me, invest it in life insurance, and that way you can pass on more money in a tax-free way in the future. Well, Lee, being a fraudster, he wasn't looking for the most reputable insurance company to go into business with. And in fact, the licensed insurance company that he had all his investors get life insurance with was a company that itself was hoping to get acquired and get out of the business. And of course, it was a company that paid Lee the highest commissions out there in the market. So Lee was getting typically 110% of the first year's premiums, and it was a way for him to further double dip on these investors. The co-conspiracy liability theory is if you play an integral role in some sort of illegal activity, even if you're not fully informed what the illegal activity is, but your participation in part of it can buy you all of the liability. So this insurance company issued policies to all of Lee's investors for the exact same amount, $1 million face value on life insurance policies, without doing anything called suitability analysis. Suitability analysis, in the most general sense, is what it sounds like. Is this policy amount something suitable for the person buying the policy? And they didn't do any of that because, again, they were looking to get acquired by a bigger insurance company, and they simply wanted more policies on their books. So in that particular case, we were able to get the insurance company involved to pay a settlement of many millions of dollars to refund to the victims all of their investment losses. And thus, that's a good example where if the defendant can't pay, you can look for and should look for some sort of co-conspirator that is economically viable as at least a second line of defense. The next example begins to bring us into the various government funds that are out there. And this is the case of James Walker and Senior Care Advocates. If I can trouble you to move forward in the slides, thank you. Great. So James Walker was a longtime Sacramento Medi-Cal planning attorney. He had a radio show. He also did the free lunch circuit up and down California state. And what he was really selling was fear abatement. He got seniors very, very worked up over this simple concept that they were going to need a nursing home overwhelmingly at some point during their life, and that they were going to need it for a much longer period of time than people do on average, and that those costs were going to wipe out a lifetime of savings. So James Walker's idea was to sell everybody, again, the exact same advice, whether they really needed it or not. To single people, he sold this piece of brilliant advice for $10,000, and to married couples for $20,000. And the advice was essentially to commit Medi-Cal fraud. His advice was to gift away all of your assets to a trusted family member or friend. Thus, if and when you needed a nursing home, like he would tell you you were absolutely going to need, you would be under the dollar amount to qualify for Medi-Cal to pay for your nursing home care. He got prosecuted by the California Attorney General, eventually disbarred. And because he was a bad attorney, we're very fortunate in California. And in fact, nearly every state has a bad attorney fund. And these funds are, super important to correct for the public bad acts by bad attorneys. And it happens and all of these funds get paid in kind of the same way or get funded in the same way, not at the taxpayer's expense, but on license renewals. So when I, as an attorney in California and Washington, pay my yearly bar dues, each state scrapes out a couple of dollars and it goes into a bad attorney fund. So if and when an attorney absconds with a client's money or steers them in an unethical direction, there's monies available through which the victim can be made whole. And that was one of the ways that we were able to recover for more than 500 of James Walker's victims. He had more than 6,000 in total. A lot of these victims as well qualified for the California Victims of Corporate Fraud Compensation Fund. And the way that happened is Walker operated his senior care advocates as a corporation, and thus the corporation's fund picked up a lot of his victims' losses. These funds are very technical. They're not nearly as easy for people to get restitution from as they might seem on first blush. They take extremely seriously their need to dot every I and cross every T and make sure that the bad acts are squarely within what they view as their victims fund restitution's purpose. So like with the attorney fund, one of the fights that we'll often fight is whether the bad acts really were in the practice of law, of performing legal type duties as opposed to investment or advisory duties, or the corporate fraud fund, whether or not the bad acts by the individual were really on behalf of the corporation, as opposed to just the bad person individually. A lot of people make applications to these funds on their own, and they'll get deficiency letters and then honestly find their way to my office up against a time deadline to cure the deficiencies. And it just simply requires a lot of investigative work to prove that the losses were in fact due to the reasons that the fund was set up to reimburse. So there's two examples. So where the defendant can't pay, look to co-conspirators, and here looking to the state bar fund or maybe to a corporate fraud fund. The next example is an example again that happens in all the states, and that's a man named Seth DePiano and the Department of Real Estate. So this gentleman was a well-known entity in Fresno, California. He was kind of a golden son to that area. He had played at Clovis High School's football team and supposedly made a lot of money in real estate, and of course attracted then a lot of investors to him. And unfortunately, it turned out to be a $24 million Ponzi scheme. So with Seth, there wasn't any assets. I mean, the government got to forfeit $700,000 of what they could find, and that's great. But obviously with $24 million of victim losses, that's not nearly enough. So what we did in that case was we looked to the California Department of Real Estate, and they too, out of their license renewals, strip out a couple of dollars every year and put it into a restitution type fund. So when realtors do unsavory acts like this gentleman, there's the potentiality of making victims whole by paying out of the fund. Again, the fund has highly technical requirements, largely focused around whether the need for a real estate license was what really drove the fraud as opposed to individual greed, and the real estate license simply being a separate component of it. But once we are able to satisfy those needs, they'll pay up to $250,000 per bad realtor. So there's the potential of getting money back for victims from that fund. And in that fund as well, the victims that came to our office were people that had tried to submit claims on their own, only to get turned down in subsequent correspondence with the Department of Real Estate. And it took our office and our investigator a fair amount of digging to prove that Mr. Depiano's bad acts really did require a real estate license, and that the real estate fund was appropriate to pay back the victims involved. My last example, as far as government funds to consider, was in the news over just the last couple of years. In fact, both of these two settlements just ended recently, but there still are opportunities to get money out of them. And these are prosecutions that the Federal Trade Commission did of Western Union and MoneyGram. And as you may know, dealing with elders, fraudsters really love to get them to wire money. And they do this for a couple of reasons. Wire funds are basically gone the moment that they're sent. They're damn near impossible to get the wires ever reversed and the money back. And it also opens up to the fraudsters a lot more geography as far as where they can target potential victims. They can be in, Jamaica, and this is the fraudsters. They can be in Jamaica or Nigeria or the UK or in Asia, and they can be corresponding via email or telephone with our older adults and pitching to them that they've won a fake lottery or a prize. Maybe that they had left behind a family member that they had never heard of, and they're set to inherit, $25 million. They just need to wire the taxes or some sort of made up administration fee, and the inheritance will be sent to them. The other frauds that are common are emergencies, that a loved one is traveling overseas and is incarcerated, or having a medical emergency, and to wire money immediately to resolve that issue. And then again, fake investment opportunities, and a lot of fake romances as well. So why would wire transfer companies like Western Union or MoneyGram ever be responsible for the bad acts of these fraudsters? Well, what happens is these frauds don't happen once or twice and then never again. These frauds happen, once or twice every day. Day after day, month after month, and year after year. And so Western Union and MoneyGram come to learn about via consumer complaints the bad acts that are going on, and they've got to make an election. They can try to slow down or stop these fraudsters, or they can allow the bad acts to continue. And in this case, they allow the bad acts to continue, and the reason is simple. They make a sizable commission on the transfers of money. It's not unusual for them to get 7.5% to 15% on the transfer of money. So that's why companies like Western Union and MoneyGram are the fraudsters. So in this case, the FTC prosecuted and got a several $100 million recovery from Western Union and $125 million from MoneyGram. And I'm happy to say that in the last year or two, we've helped more than 500 victims recover more than $4 million from these two funds, and dealt with the elders typically being unable to produce any sort of proof. So we have to get proof from family or banks, or subpoena it, or not have any recollection of it, or sometimes the victims had died, and so we end up representing the families. So how can you help victims in situations where there's financial fraud suspected? The first place that you can really start, as indicated on the next slide, is just with some basic internet research. If you'll help the elder by simply Google searching the name of the bad guy or bad company and type the word fraud after it, you'll be surprised how many reports by other victims come up. And then if that's what you see, and that's what it sounds like has happened, consider urging the senior or their family to connect with an attorney, at least to consult with a civil attorney to see what can be done. And in selecting a civil attorney, the criteria should be fairly simple, not unlike if you or I were to go out and find a doctor or a dentist or an attorney for our own needs. They'd want to know what type of experience the attorney has representing seniors from the past, what type of results they've been able to do, and then very importantly, whether or not there's any cost or risk involved by the senior or the family having the attorney go to bat for them. I'm happy to say that in 29 years of doing this and having represented thousands and thousands of older Americans and families, we've never done it on any other way other than on a contingency and on a risk-free basis. Because again, the last thing we want to do is take an older American who's been defrauded down a year of litigation only to come to a zero end point and then them having to pay fees on top of it. What resources are out there? On my website, I'm happy to say there's a video series that I produced on both financial abuse and physical abuse cases, warning signs and suggestions how to avoid and what to do if those things happen to come up for you. I also have a practice that involves elder physical abuse, but candidly, physical abuse is such a big topic that I think it's best left for another time if there's an interest for it. And then lastly, with regard to civil attorneys, if you were to steer an elder or their family towards a civil attorney, I think that there's this one pretty important rule of thumb. If you go to the attorney's website and at least 80+% of the content doesn't talk about representing elders and the results that they've had for elders, then you probably don't want to select that attorney. And that's not to say that that attorney isn't a fine person and a fine attorney on the other areas of practice, but candidly, elder abuse is such a changing and complex and specialized area of the law. And there's enough people that specialize on it alone that if I had to give members of the public a rule of thumb, it would be to look for attorneys and really scrutinize their web content. And again, if it doesn't involve 80 or 80+% involving elders, you probably want to look for a different attorney. So I hope that that's of some help and gives you an idea of what can be done in cases of financial elder abuse by professionals and by businesses. I didn't address today in this talk elder financial abuse by family members or trusted friends. Unfortunately, we probably all know that that is 90% of the financial abuse that happens out there in the elder world. And I do those cases as well. But I wanted to present to you today what I hope is new and novel material about what happens when the fraud is by a professional or a business, and it's not always clear that the fraudster or their business is economically viable anymore. To let you know that candidly, a good civil attorney will do what we've discussed here today, and that is look for co-conspirator liability or look for various restitution funds to try to make the elder and their families as whole as absolutely possible. So with that, I thank you for listening and allow Nicole to facilitate any questions.
Thank you, Mark. We appreciate you and providing all that information. Want to remind everyone that you can leave your question in either the chat or the Q&A box, whichever is best for you. I've been here with my team member, Christy, and we've got a couple questions that spring to mind for us. So we'll go ahead and start there. So you talked about if an attorney has, if 80% of their website is not talking about older adults, that may be not the best fit for you. But I'm not a fancy person and knock on wood, I've never had to retain an attorney. So I don't know if I go to an attorney, what do I have the right to ask before retaining them? What information can I set an appointment to meet with them or their team member? What can I ask at that meeting that will help me discern if they're the right fit for me?
Thanks, Nicole. That's a great question, a great place to start. So you're the consumer. Nothing happens without your okay. So the short answer, and then I'll expand on it. The short answer is anything that will satisfy you as the consumer, that the person sitting across the desk from you is the right person. So I would ask them about how many years they've been in practice, how much of their practice is related to senior issues, older American issues, what types of past results they've had. Can they tell you specifically about cases like what you're bringing them presently, that they've had experience in those cases and what type of results? And then again, a fee structure that is protective of the senior, a contingency fee situation, preferably with zero risk to the senior or their family, that if the case results in a zero outcome, that their life will ever be any worse for having tried the civil litigation route.
So when I'm at this meeting, and let's say like they start talking maybe a little fast, I'm a little confused, I might not be clear. At what point is it reasonable? Should I expect like I'm going to have to pay some sort of fee to retain them? And so at what point does that happen? And what if I just don't have the money? Does that mean I just can't get a civil attorney?
Both, again, great questions. Thanks, Nicole. So the point that you should ever open up your paycheck, your checkbook and write a check to an attorney, in my opinion, is never. That attorneys should write you checks. You shouldn't be writing attorneys checks. Mm-hmm. So I've had so few occasions where a family was so affluent and so sophisticated that they wanted to engage me on an hourly basis. That is not even worth talking about. For 99.9% of the public out there, they should be only engaging attorneys if it can be done in a contingency, risk-free basis. And I'm sorry, the second part of your question then, Nicole went on to ask what?
What if I don't have money? Like, what if I don't have the ability to write a check to retain an attorney? But it sounds like you're saying part of the way that I would know that someone's legitimate is if they're saying, no, I'm not going to charge you. That's going to be on contingency to take off on sort of once there's a settlement.
Precisely.
Okay.
Exactly right, Nicole.
Okay.
Yes.
We have some good friends in the chat reminding us that there are some ways to look up attorneys. So how can I use my County Bar Association's website to check information about an attorney? And what should I look for if I do that?
Great. So you can use both the state bar's website to make sure that the attorney is a member in good standing. County bar associations don't typically have any further information than the state bar does. And beyond that, you can ask an attorney to talk to past satisfied clients. It's a big ask because now you're asking satisfied clients to share their experience. But thankfully, older Americans and families tend to be very gracious and willing to do that for attorneys that they believe in. So that's not an unreasonable question for somebody to ask as well.
Mm-hmm. Okay. And we also have in the chat reference to CANR, California Advocates for Nursing Home Reform. I want to remind everyone that they have some real connections to some great established elder abuse attorneys.
And I think so too, Nicole. CANR got certified many decades ago as a legal referral service, and that requires jumping through quite a few hoops with the state bar. And in fact, I've been a member of CANR for 20 plus years myself. And so I think the world of them. CANR stands for Californians Advocating for Nursing Home Reform. They have an 800 number for consumers. They can call and ask to talk to the lawyer referral service there. They'll put them in touch with attorneys either of the financial abuse nature or a physical abuse specialty that can potentially be of help. They're a big enough organization that they have attorneys statewide. They're a great resource for people. And I don't know if this is too much to say or not, but if anybody ever wants to just simply email me and ask for help in a different jurisdiction or place, email is an especially easy way to get a hold of me. and I'll do my best to put them in touch with somebody that's a known commodity and that I think is competent, at least for them to interview, and happy to do that as a courtesy for anybody that's interested.
And interpreters asking, do you mind in the chat to type that acronym? I got all the words, but not the acronym. Would you mind?
Absolutely. We'll do that here for you. Thank you so much, Cindy. We appreciate that. And you are just right on point, Mark. We have a question here of asking, so much of family dynamics happens across state lines. Oftentimes our parent may be in one state and we are in another, or even another country. And so I think it's really the question is, can we, if we have an issue where our parent we think they're being abused in another state, should we consult an attorney in that state, or can we look for an attorney in the state where we're living?
So great question, and it really depends. Typically, the litigation will need to be venued in the location where the older American is. But it doesn't mean that it isn't fine, and especially at the consultation level where it's not costing anybody, to consult somebody legally, kind of to do the screening process of whether or not it is meritorious to consider actually hiring somebody in another state. And then the other possibility is you might have situations where there's attorneys in multiple states involved, and that's part of what I do with the Pro Hoc Vice, where I'm allowed to basically petition a court that in cooperation with local counsel, that myself and the local counsel, who's an out-of-state counsel in a jurisdiction that I'm not licensed to practice, can co-litigate the case together. And in a contingency setup where it doesn't cost you any more to have two attorneys involved, I can't see why people wouldn't be interested to do that. And then typically the two attorneys come to an arrangement as far as how the fees are split, and that split gets disclosed to the clients at the time that the matter gets taken up. So everything is transparent. You've got a local counsel in the jurisdiction where the case will be venued, and maybe a counsel local to you, where you're located as well.
And is that the responsibility of the attorneys to set up, or do I, as the consumer or advocate, have to have a cousin in one state and that I know a friend from college in another that can work together?
Yeah, it's not your responsibility as the client to put together the legal team. You just need to find somebody that you're comfortable with, and then typically they'll go out and find somebody in that jurisdiction. For example, I belong to multiple listservs with attorneys from across the country through AAJ and through Trial Lawyers College and other groups such as that. And if I don't know people, I'll put out their request for referrals, and then I'll start the process of interviewing attorneys that might be suitable in a case like this. And it depends a lot on the complexity of the case as far as what you really need. If the case really is an elder case, but you simply need somebody with a license in another state, you'll pick one type of attorney. If you need an attorney with a lot of firepower as far as taking depositions in another state, you might pick a different person. If what you think you're going to have is really complicated estate planning and tax issues in a case, you might pick a different attorney yet still. And it's never the consumer's obligation to put together kind of that winning complement of talent. It's really the attorney's responsibility. And candidly, the attorney would rather be responsible for putting together the team.
Mm-hmm. Are there any helpful listservs or attorneys interested in an area of elder abuse? Is there just any, is it really just the attorneys that see other attorneys, or is there anything that we as consumers can go to specific listservs and see information?
There are not specific listservs that I'm aware of. I think the closest thing that there would be like contacting a canner and asking them, and Canner's CANHR, and their website is canhr.org, canner.org, would be to consult them. Or again, if people wanted to email me, or if you've got a family friend who's an attorney, start with them and let them do some of the legwork for you as a favor to see what can be accomplished.
Okay. So oftentimes when something's not going right, we have reached out to adult protective services, the ombudsman, we reach out to, the law enforcement, and we reach out to private attorneys all at the same time. It's a flurry of activity. So in that scenario, is there an order of what takes precedence of civil over criminal or criminal before civil, or can they move at the same time?
Great question. Complicated question. They can move at the same time, depending upon how early in the process you are. Investigation can happen from both a civil end and an APS and a criminal end simultaneously. But once there's criminal litigation that's active, there's a Fifth Amendment, a constitutional Fifth Amendment privilege against self-incrimination, whereby a criminal action typically takes precedence over the civil action, and my action would be stayed by the court pending the outcome of the criminal matter. But in all candor, criminal prosecutions are rare. It requires really egregious acts, typically large numbers of victims and large amounts of money lost, to really justify the resources of our local DAs and attorney generals to prosecute those cases. So while the investigation can and should all go forward together, it's not uncommon for the criminal attorneys to not move forward on a formal prosecution, and then it be left kind of for the civil attorneys to jump in and do what they can to make the elders whole, and hopefully secondarily, to make it hurt bad enough against the fraudsters that they're not in business anymore. I'm happy to say, with all the examples we talked about today, these are folks that got put out of business via either the criminal prosecution, or if not there, by our civil prosecutions.
Can a civil attorney ever help to get the police involved? And what I mean is, I oftentimes hear from families saying, I can't quite get the police to understand that this really is a criminal issue, or the victimization is continuing, or something is really egregious is happening. Is it ever helpful to retain a civil attorney and pursue that course of action? And that attorney also can sort of help make the case to law enforcement of why there should also be a criminal case as well?
Absolutely. Absolutely. It can help to have the civil attorney be kind of the mouthpiece of the family and kind of sort the facts out as they think that they're most sellable to law enforcement as a future criminal prosecution. The other thing, in all candor, for the attorneys, those of us that do elder financial or physical abuse, typically will know the DAs, the prosecutors in our local areas, and or the criminal investigators, and be able to pick up the phone and have a conversation about a case that we think is particularly egregious, and why we think that this is one that really should move up the ladder as far as investigations go.
Okay. Is there a sort of statute of limitations on civil work? I mean, if this happened, maybe something happened and mom passed away and we were very traumatized, and it's maybe been a year before we can even think about an issue. Is there a length of time that we have to wait before we just can't do anything else with that information?
Sure. Great question again. So the key concept there is not to wait, is the short answer. The legal answer is in the case of elder financial abuse or elder fraud, it's 4 years from when the elder knew or should have known of the bad conduct, of the fraudulent conduct. But even there, I've prosecuted cases where the bad acts were much older than 4 years, under the idea that fraud is a continuing civil tort. Mm-hmm. So if the fraud is continuing, and it's going right up till this day, that the elder's continuing to be damaged because they don't have their money, because they don't have their service that they were promised by the bad guy. I've been successful in getting quite old cases 5 and 10 and more years old, through at least the restitution claims process, because the fraud was a continuing civil tort, and thus still timely to make restitution to a victim.
Mm-hmm. So who can contact an attorney to pursue a case? So I'm thinking of a lot of issues where I hear one family member concerned about the way another family member is taking care of mom or dad and feeling like there's some fraudulent activity. Who is allowed to contact you, the attorney, and petition the court on behalf of an older adult?
So anybody is, the telephone is obviously an open modes of communication. Anybody can pick up the phone and start the process of consulting with an attorney. That truly is open to anybody that's concerned about what's happened. But then underlying that question is who's really permitted in the legal arena to represent the older person. And it depends if the older person is competent. It depends if the older person is willing to go through with litigation in certain cases. And these are mostly cases where it's family members involved and the older adult won't want to go against somebody that they've got a family bond with. You'll have the super unfortunate, but unfortunately necessary step of getting conservators appointed to pursue the litigation because the elder is reluctant and maybe has diminished capacity whereby they can't handle the litigation on their own. And courts will literally have a conservator hearing and make a determination on that.
You know, we've talked about like really assuming that a case goes to court, but is it ever useful for someone to contact an attorney to have the attorney write a stern attorney letter that would go out the fraudster to stop it? Essentially saying, look, we recognize we're probably not going to get the money back, but we need this to stop and we need, you know, a scary attorney to make that happen for us. Is that ever something that you and your colleagues do, or is that just not in the cards?
No, that's very much in the cards. That's a great idea. And it really is a frequent step one, because that letter and, you know, query whether we would want, and we'd have to strategize based upon the case, but query whether we want that letter on legal stationery, or we would simply want to ghostwrite the letter for the elder to send out. Because what happens then when fraudster doesn't do anything on that request to return the money is that certified letter that went to the fraudster becomes exhibit number 1 in the future civil case that we do. So I think your question is right on. And there are occasions when I write the letter on my letterhead where I think that there's a chance of scaring the money back to my client or my client's family. And if there's not, and I think it's going to go down the litigation rabbit hole, it seems to be more sympathetic to kind of work in conjunction with the client, kind of ghostwrite for the client a letter and then have them send it certified. And when like I said, the fraudster does nothing, that becomes a beautiful exhibit 1 in your case. And you're putting the fraudster on their heels, having to explain why they got this clear request from an older American or their family and just, you know, blowing them off.
Well, Mark, thank you so much. This was a really interesting topic for us. I just have one last question. It really brings us back to our core topic of how do we as service providers work with clients and civil attorneys. And so if we were to refer a client, sometimes they need help getting there, they need transportation, or a case manager might go with them. Is it at the time when the client gets there, do they have to sort of the case manager sort of step out of the office? So it's just you and the client in the room. How do we navigate that first appointment?
It really depends upon the wishes of the client. And I have to tell you, Nicole, more and more, everything's happening virtually. So I think it lessens the pressure for people to just meet in a Zoom meeting or on a phone conference, you know, at no cost, with no commitment. It's just hopefully 3 good souls brainstorming about a bad situation and what might be done. And in that case, while I frequently will want to hear as much as I can from the older American themselves to see, you know, kind of to test what their memory is like and kind of gauge their emotional support behind the idea of righting the wrong. I welcome anybody's involvement at that early stage when they're consulting with me. So I'm happy to talk to neighbors, caseworkers, family, friends, anybody to just get the ball rolling.
Excellent. Mark, I want to thank you for joining us today. We have learned a lot. We appreciate your career-long service to older adults and always being willing to share your knowledge and expertise. I want to remind everyone that, first of all, Mark put his contact information up. Can we put that on the screen for a moment? Feel free to reach out to him and hopefully, pull his information as we have. I want to thank our interpreters and our closed captioners today. Without you, this work would not be possible. I want to remind everyone that next month is Residents' Rights Month. It's a month that we set aside to commemorate the contributions and the dignity of those who live in long-term care. So we have a mystery guest coming to join us, but be sure to register. We want to pull back the curtain on what's going on in long-term care and let all of our partners understand that dynamic and landscape a little bit more. You are the first folks who have access to that link, so go ahead and click it now and register. Be sure to share that with a friend. We look forward to seeing everyone back here next month. Thank you for your time and for all of your work. Have a wonderful day.